How do I change? Oh, we are in this thing. My bad for the quick pause, but we got to make sure to get things right. Y'all already know. Loading. Yeah, you already know how it is, man. We got to get things right. Let's get them right, Captain. I hope all of y'all are doing good. I hope all of y'all are blessed. My name is Cameron. This is Power Inherent in the People. This is where we comprehend and know for a fact that we are a creation of the Creator and that all power is inherent in us. And there's no way that we are going to let that power that is inherent in us diminish, falter, or fail, because we all have the Spirit of God within us. Now, whatever you title that is up to you. But I'm going to tell you right now, I'm going to title it what I title it: the Great Creator, the Most High, the all-encompassing and all-unknowing that is beyond English intellect and comprehension, okay? And I am so grateful for this life. And today we are going to go into a little bit of objections, okay? This is going to be all the way through part 1 today. And again, this is going to be in relation to advanced objections for pro se litigants, Sui Juris. This is going to be a comprehensive study guide, okay? I actually haven't released this to anybody, just so you know. We did some revisions yesterday on the 12th, but beyond that, yeah. So first part's going to be on the foundational principles and strategies, on metaphysical foundation objections on the creator endowed right to be heard and challenge authority. Then we're going to dive into some objections as manifestations of natural law and principles. And then we're going to go on to the ontological distinction between procedural objections and substantive rights assertions. 1.4 is going to be about the practical application, objections in the context of corrupt officials. And then part 5 of 1 is going to be the conclusion, of course, of the transcendent significance of objection practice. So hopefully this is helpful for y'all in some sort of way. What I first want y'all to do is go ahead and smash the like button if y'all are in here. And if you want to say something in the chat so I can give you a shout out, I will do that before we get going. I'll give a shout out to some of the people who are already in here right now, which is Dawn. What's up, Jonathan? Hope you're doing well, brother. Lim, nice to see you, Lim. Bob, I see you in this thing, Bob. Hopefully everybody is doing great and blessed on this beautiful Friday. So let's get into part 1. It's going to be the metaphysical and foundation objections. Okay. The right to object, to raise one's voice in formal protest against perceived injustice or procedural irregularity, transcends mere procedural mechanics and finds its ontological foundation in the creator-endowed right to be heard. This metaphysical principle precedes and supersedes all positive enactments, deriving its authority not from governmental grant, but from the immutable nature of human dignity as bestowed by the Creator. That right there is deep. What's up, John Bravo? What's up, Tribe? What's up, Love? Hope all y'all are doing good. This metaphysical principle precedes and supersedes all positive enactments, deriving its authority not from governmental grant, but from the immutable nature of human dignity as bestowed by the Creator. The right to object emanates from 3 interconnected metaphysical principles that exist independent of and prior to governmental recognition. The inherent human dignity. Clearly, the Creator has endowed each individual with inherent dignity that demands recognition and respect from all earthly authorities. Oh my. Are we receiving the inherent dignity and respect that demands recognition from all earthly authorities? I guarantee you that is not the case. I promise you that is not the case. It's not happening. And that's the problem I'm seeing in this nation and what we have to fix. This dignity includes the right to speak in one's own defense when threatened with adverse action. As articulated in Genesis 1:27, we are created in the divine image, establishing an ontological status that transcends mere subjection to authority and includes the capacity for reasoned discourse and challenge. If you ain't challenging, what are you doing? If you are acquiescing and saying, oh, but Jesus just turned his cheek, so should I, what does that do for one who can't even stand for himself and just get constantly abused? Who doesn't have the intellect to be able to stand and know their rights like we know them? When a pro se litigant raises an objection in court, they manifest this creator endowed dignity by refusing passive submission to potentially erroneous or unjust proceedings. Do you see how deep it is? You have a duty. You have a duty as a creation of the creator. The objection itself represents an assertion of personhood against the machinery of institutional power, a declaration that the individual stands as a moral equal to the tribunal before which they appear. And you can appear in lots of different ways, mind you. Natural justice. The principle of natural justice, that no one should be condemned unheard, and that no one should judge their own cause, derives not from the positive enactment, but from the metaphysical reality of human moral equity before the Creator. These principles exist independent of governmental recognition and impose binding constraints on all legitimate authority. Legitimate, mind you. If they're doing something outside of that, it doesn't make it legitimate now, does it? The right to object operationalizes these natural justice principles by providing mechanism through which the unheard may demand hearing and the potentially biased adjudication may be challenged. Okay? Biased adjudication. Bias, just a little bit of that perception of a bias is enough for me. When a pro se litigant objects to a prosecutorial misconduct or judicial bias, they invoke not merely procedural rules, but metaphysical principles that transcend positive enactment, that reverberate into the galaxy and reality in which we live. It's deep. It is that deep. Oh, he's crazy. Okay. Let me show you some more crazy. Truth-seeking imperative. The Creator has established an objective moral order in which truth possesses inherent value, independent of utility or convenience. Oh my God. This metaphysical reality imposes obligation on all participants in adjudicative proceedings to pursue truth rather than mere procedural regularity or institutional convenience and or funds. Monetary values. That's on a metaphysical level, though. I know it's hard for people to even comprehend a metaphysical level, but we're going to help you with that. I got you. Papa Cam's got you. The right to object serves this truth-seeking imperative by providing mechanisms through which factual errors, logical fallacies, and procedural irregularities may be identified and corrected. When a pro se litigant, such as you and I, that's what we are, objects to irrelevant evidence or improper questioning, they serve not merely their own interests, but the transcendent value of truth itself. Let's get into a little bit of the biblical foundations for the right to challenge the authority. You dig what I'm talking about? Because we all got a faith. See, the problem is they took away our faith and belief and tried to put it below their rules, statutes, and policies. But if they did that, then that would be a deprivation of rights under the color of law. And a law, at least a colorable one, is any statute, policy, ordinance, or whatever else you got out there to title. Because the only law that I abide by is God's law, natural law. Why is that? Because I don't hurt anybody. This reality is of my own free will and volition. I can do as I please because I don't hurt people. Let's get it right. How do I get back to my share? Where's my share button? Share screen. Thank you. Appreciate you there, guys. Creator endowed right. Y'all need to understand this creator endowed rights aspect and how deep it truly goes. It is beyond all statutory. It is beyond all constitutional. It is beyond anything that you think of. Creator endowed rights supersede everything.
to challenge authority finds abundant support in biblical precedent, establishing its status as divine ordinance rather than mere human convention. Abraham's intercession. Now, in Genesis 18, chapter 18, verses 23 through 33, Abraham directly challenges divine judgment against Sodom and Gomorrah, asking, quote, "Will you indeed sweep away the righteous with the wicked? Suppose there are 50 righteous within the city. Will you then sweep away the place and not spare it for the 50 righteous who are in it? Far be it from you do such a thing, to put the righteous to death with the wicked, so that the righteous fare as the wicked. Far be that from you. Shall not the judge of all earth do what is just?" Unquote. This remarkable passage establishes that even divine authority may be respectfully questioned when justice appears threatened. Abraham's objection, for it is precisely that in both form and substance, demonstrates that challenging authority when fundamental principles appear violated constitutes not rebellion, but righteous advocacy. If the Creator himself entertained such objections, how much more must earthly authorities respect the right to challenge their judgments? Moses' intervention. In Exodus chapter 32, verses 11 through 14, Moses intercedes when divine judgment, threatens Israel after the golden calf incident. Quote, "O Lord, why does your wrath burn hot against your people, whom you have brought out of the land of Egypt with great power and with a mighty hand? Why should the Egyptians say, with evil intent did he bring them out, to kill them in the mountains and to consume them from the face of the earth? Turn from your burning anger and relent from this disaster against your people." Unquote. This intervention, functionally equivalent to objection in judicial proceedings, demonstrates that advocacy against potentially excessive punishment serves divine purposes rather than frustrating them. Moses' objection appeals to principles beyond immediate circumstances, beyond your immediate needs, beyond the pain and suffering that we have to go through to receive justice, beyond the sleepless nights that we have to go through, the PTSD from these people egregiously bringing harm to us when we've done nothing but stand on what God has invoked us to do. Invoking covenant promises and reputational concerns that transcend the immediate offense, the immediate fire that we must all go through to strengthen yourself and know that internally you truly are a great part of the I am. Job's demand for hearing. The entire book of Job presents extended meditation on the right to challenge seemingly unjust treatment and demand hearing before divine tribunal. Job repeatedly insists on his right to present case directly. Quote, "I would speak to the Almighty, and I desire to argue my case with God." Job 13:3. This insistence on procedural injustice, you know, that rule of 3, 3, 6, 9, I'm going to keep going. The right to be heard and challenge adverse determinations establishes objection as fundamental right rather than mere procedural technicality. Significantly, the divine response ultimately vindicates Job's persistence in demanding hearing, establishing that respectful but firm objection to perceived injustice aligns with divine order rather than transgressing it. Don't you get it? Don't you get it? When Job declares, quote, "I would lay my case before him and fill my mouth with arguments," unquote, Job 23:4, he articulates the essence of objection practice. Reasoned challenge to adverse determination based on principled disagreement. It's an internal knowing. You breathe it. It exudes from you. It is something that cannot be broken. And it's all in uprightness. It's all falls, everything that is out here based on supposed law is backing our beliefs. Paul's appeal to Caesar. In Acts 25, chapter 25, 10 through 11, the Apostle Paul demonstrates the legitimacy of appealing to higher authority when facing potentially biased proceedings. Quote, "I am standing before Caesar's tribunal where I ought to be tried. To the Jews I have done no wrong, as you yourself know very well. If then I am a wrongdoer and have committed anything for which I deserve to die, to be harmed, to be punished, to be brought to jail, to be having my private property stolen, to be ridiculed, to be put in torture handcuffs, whatever the case may be, I do not seek to escape such punishment, for I'm standing in all moral integrity. But if there's nothing to their charges against me, no one can give me up to them. I appeal to Caesar. Man. This appeal, functionally equivalent to objection to jurisdiction or venue, establishes that challenging procedural irregularities and potential bias constitutes legitimate exercise of rights, God-given rights, rather than disrespect for authority. Bring forth someone who has a claim that I have done wrong against them, and I will be more than willing to succumb to those claims. But it will never happen. You will never have that happen to me. There will never be a person that comes and says, Cameron harmed me. That ain't my spirit, man. And it ain't yours either. Deep down inside, I don't care where you are in life. That's not you either. Paul's objection invokes higher legal principles against potentially corrupted legal proceedings, establishing pattern directly relevant to contemporary pro se litigants facing potentially biased tribunals. So the historical evolution of objection rights. So the creator endowed right to object has manifest all throughout legal history. And we just touched base clearly on the little Bible, but it's all throughout, evolving from implicit recognition to explicit procedural protection. Now, in ancient legal systems, even they, predating explicit constitutional protections, the right to challenge adverse testimony and procedural irregularities received recognition. The Babylonian Talmud contains extensive discussion of evidentiary challenges and procedural objections, establishing that the right to contest adverse evidence derives from principles of natural justice rather than mere positive enactment of some who say that we are supposed to abide by such, that you are mandated, you are required. And all I can say to that, really, all I can say to that is administration of a free man is repugnant to his freedom. Therefore, meaning that you cannot regulate me. Your requirement is null. It's a nullity. It's ab initio null from inception in the beginning, from you stating it and putting it on record. Because I must be willingly, knowingly, and intentionally subjecting myself to your presumptions of supposed color of law, statutes, revised codes of Washington, all of these aspects. They're not. Now, let's get it right. Where there involves crime, where there involves harm, for sure, 100%. You do something bad to any one of my relatives on this land, on any land, but especially this land, you should be held liable. And I'm down for your ass going to jail and paying the price. No ifs, ands, or buts. God's law runs here, homeboy. Roman law, similarly, recognized the right to challenge testimony and procedural irregularities, with specific provisions for objecting to witness competence and questioning techniques. These ancient recognitions demonstrate that objective rights derive not from modern constitutional innovation, but from the perennial principles of justice that transcend particular legal systems. So let's get into some common law development, y'all. So the English common law tradition developed increasingly formalized objection procedures, recognizing that adversarial testing of evidence serves truth-seeking function essential to just adjudication. Sir William Blackstone's commentaries on the laws of England extensively discusses evidentiary objections and procedural challenges as establishing their centrality to common law adjudication. This common law heritage directly informs American jurisprudence regarding objections, establishing historical continuity that supports understanding objection rights as deeply rooted in the nation's history and tradition rather than mere procedural innovation. When contemporary pro se litigants assert objections in the right way, they participate in jurisprudential tradition extending back centuries before the Constitution's ratification. Got it? Now, the Sixth Amendment's confrontation clause explicitly constitutionalizes certain aspects of objection rights, guaranteeing the right, quote, to be confronted with the witnesses against him, unquote. Now, this is huge. Can anybody in the chat tell why this is huge? What does that mean? Be confronted with the witness against him. What term do we utilize a lot of in relation to be, where's the witness? I need a what? I need a what? I'm looking for it in the chat. I need a what in the chat? Bing bong. Corpus delicti. Where's the witness that's bringing forth the claim against me? An injured party. Injured party, corpus delicti. This provision operationalizes the creator endowed, of course, right to challenge adverse evidence, transforming metaphysical principle into explicit constitutional protection. So if one doesn't have the adverse evidence or any evidence, or the evidence is not given to him or destroyed and not preserved, what do we have going on? It's clearly constitutional protections are being violated. Therefore, the case cannot proceed. The due process clauses of the 5th and 14th Amendments similarly protect procedural fairness. Excuse me, y'all. Sorry. This happens from time to time. I do that. The due process clause of the 5th and 14th Amendments similarly protect procedural fairness, including the right to raise objections and procedural irregularities. These constitutional provisions do not create objection rights, but recognize and protect pre-existing rights derived from natural law principles. So contemporary procedural rules governing objections, including the federal rules of evidence, we all need to learn those bad boys, federal rules of evidence, and their state counterparts, represent procedural implementation of metaphysical principles rather than mere technical requirements. Represent procedural implementation of metaphysical principles rather than mere technical requirements. These aspects of what's in the federal rules of evidence, again, are giving us the implementation of our metaphysical principles, those deeper aspects of what we need to bring forth. It's not just rules. You dig what I'm saying? It's going to help you gather and understand how deep you are as a living being. These rules operationalize the creator endowed right to challenge authority and contest adverse evidence, providing practical mechanism for exercising those rights that exist independent of and prior to governmental recognition. Now, when all of you master these procedural rules, you're going to be able to access not merely the technical requirements of what we are constantly going through all of these maxims, through all of these doctrines, but practical implementation of natural rights that transcend the positive enactment, bringing us right back to the creator endowed rights and understanding why we utilize terms such as life, liberty, and the pursuit of happiness. There's a process to all of this. These rules themselves derive legitimacy from their conformity with metaphysical principles regarding the human dignity within, natural justice, and truth-seeking imperatives. Now now we're getting into the objections as manifestations of natural law principles. Beyond their procedural function, objections manifest specific natural law principles that transcend positive enactment and derive authority from creators' established moral order. Natural law recognizes truth as objective reality, independent of human perception or preference. Natural law recognizes truth as objective reality, independent of human perception or preference. A transcendent value that exists whether acknowledged or not. That's why want of jurisdiction is such a big thing, and we speak of it so freely. You can want the jurisdiction all you want. For real, for real. Keep wanting. Just keep wanting. You better prove it without a reasonable doubt. This metaphysical reality imposes moral obligation on all participants in adjudicative proceedings to pursue truth rather than the mere procedural victory or institutional convenience. Objections. Now, see, that's a big one for me because that's where I was at. I was that person. just winning just to win on the back end and prove myself and my friends. Until it got to the point where it was like, well, man, there's a lot of people suffering out here. We really need to change our nation. We really need to make sure to change and enforce what is already known as a right and what's established as a privilege. The cops out here say it all the time. They know what they got to say to get you confused. They ain't stupid. Driving's a privilege, not a right. Bro, I agree with you. That sentence, that phrase is not going to work anymore on us. We're not getting confused by that statement no more. We agree with you. Driving on the roads is a privilege, not a right. I'm in agreement. So quit. You're going to have to quit using that one. For real. Objections operationalize this truth-seeking imperative by providing the mechanism through which factual errors, logical fallacies, and procedural irregularities may be identified and corrected. When you, as a pro se litigant, sui juris litigant, objects to irrelevant evidence, improper questioning, or prosecutorial misrepresentation, they serve not merely their own interests, but the transcendent value of truth itself. You understand how valuable it is to live in truth yourself. Listen, something that I've realized over these past few months is that I can't force anything. I really got to lay down my life for the great creator and ask, great creator, what is it that you want me to do? In some things in my life, I've literally wanted to say, forget all that and force what I want to be. But it gets to a point where you're like, I just got to let things be as God wants them to be. And I see why in other religions or cultures, they say God willing a lot, because it can't be my own. You have to really allow yourself to fall into the great creator's arms and trust in this universe, and then make the proper steps to make it happen. And nobody's doing this because we want to fight and we want to win. It's not about the ego. It's about the harm of people every single day for no reason. For no reason. For no reason. For no reason. Equality before higher law. So natural law establishes fundamental moral equity or equality of all persons before principles that transcend positive enactment. Again, this metaphysical reality imposes constraints on governmental authority, prohibiting procedural advantages or disadvantages based on status rather than relevant differences. Objections operationalize this equality principle by providing a mechanism through which procedural advantages may be challenged and neutralized. When you object, the prosecutorial privileges or judicial favoritism that's always prevalent, they invoke not merely procedural rules, but metaphysical principles that align with us regarding the human equality before higher law. Like, it's so important because that's why I say if you go in and try and speak with that DA beforehand, you're invoking more of this metaphysical connection. You're invoking a connection of human essence to say, this is me. I know you deal with serious crimes. There is no crime here involved. There were crimes that were done to me on the like I was seriously violated. My constitutional rights were violated. Due process, like 100%. See, it's like we forget that there's a process to all of this. Like, you could literally say, what's the emergency? Blase, 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 whatever the case may be, reserve all rights and shut up. If they don't have a crime, what is there to move? Natural law recognizes rationality as essential characteristics of legitimate authority, distinguishing just governance from mere power. This reality imposes the obligation on all participants in adjudicative proceedings to conform their actions to rational principles rather than mere will or preference. Now, let me see here. Now, natural law recognizes conscience as an inviolable domain beyond legitimate governmental coercion, the voice of moral truth that we stand in within the human person that warrants protection against attempts to override its dictates. Again, Oh man, this is the wrong one. Oh, oh shit. Wait a second. Wait a second. Oh no. Oh man. Dang it. Bro. This is how it goes sometimes. When I move too fast, I do the wrong things. Okay. So I'm going to continue on this one anyways. That's how we do it. We're going to switch it over because I pulled in the wrong one in the first place. But it's all good. We get into it. All right. Now let's get into a deep dive into the subject matter jurisdiction. Okay. Subject matter jurisdiction, denoted in Latin as jurisdictio rationale materia, refers to the inherent authority of a tribunal to adjudicate controversies of a particular type of substantive nature. It is an axiom of jurisprudence that a court cannot lawfully act, and its pronouncements are bereft of legal effect if it is divested of jurisdiction over the subject matter of the dispute. This is not a mere procedural bagatelle, but a fundamental circumscription of judicial power, deeply rooted in the constitutional and statutory mandates. Now, the seminal jurisprudential pronouncement in Steele Co. versus Citizens for a Better Environment in 1998 emphatically underscores that a tribunal devoid of subject matter jurisdiction acts ultra vires. Its decrees are consequently rendered void ab initio, not merely voidable. This principle is held as sacrosanct within, of course, our American legal tradition. Federal courts, for instance, are tribunals of circumscribed jurisdiction, meaning their adjudicative authority is strictly limited to those cases expressly authorized by the United States Constitution and federal statutory enactments. State courts, whilst often possessing broader general jurisdiction, are similarly constrained by their respective state constitutions. Legislative provisions. Let me see if I get this on Do Not Disturb. My bad, y'all. For an hour. Now for an exemplar articulation for contesting subject matter jurisdiction. Quote, objection. Your Honor, this tribunal is demonstrably devoid of subject matter jurisdiction requisite to adjudicate the instant controversy. The gravamen of the complaint as presented before this court pertains to matters falling unequivocally outside the constitutionally or statutorily prescribed purview of this honorable court. Specifically, and then you would articulate with precision the particularized reasons for the jurisdictional deficiency, e.g., whether it was the matter is exclusively reserved for adjudication by a tribunal of specialized jurisdiction, or the quantum of damages sought fails to satisfy the monetary threshold for this court's jurisdiction. Or again, the constitutional violations on the forefront outweigh the claims in which they're bringing forth upon you. You know, and that's even speaking on the aspect of, is there a contract even in place? You dig what I'm talking about? Ergo, any proceedings undertaken herein would be coram non judice, and any resultant orders or decrees would be rendered void ab initio, unquote. I'll take that. A profound apprehension of the ambit of the tribunal's subject matter jurisdiction constitutes the prima facie line of the defense for any litigant or movement in a case. Such apprehension necessitates a meticulous examination of the substantive nature of the claim. I need a nature and cause, and the intricate legal framework governing the specific court in question. An early and jurisprudentially well-founded objection predicated upon this ground possesses the capacity to summarily terminate proceedings that are improperly venued before the court. My boy, I was just watching Tano. Tano was just talking about this. Thereby obviating considerable expenditure of time, pecuniary resources, and potential prejudice. Now, if we're going to challenge the personal jurisdiction and improper service, the authority would be the Federal Rule of Civil Procedure 12b2, okay? And this is going to be to explicitly sanctions a motion to dismiss predicated upon a deficiency in personal jurisdiction. And whilst 12b5 addresses dismissal for insufficient service of process, okay? You can see it come down here, Federal Rule Civil Procedure 12b, motion to dismiss for lack of personal jurisdiction. And Federal Civil Rules of 12b, again, for a motion to dismiss for insufficient service of process. Okay. Now, the constitutional due process guarantees, as enshrined in the 5th and 14th Amendments, are the paramount significance, ensuring that an individual is not involuntarily subjected to the jurisdiction of a tribunal in a remote or unduly burdensome forum, absent a legitimate and substantial basis. The procedural mechanics of service are also rigorously prescribed by statute and court rules, e.g., the Federal Rules of Civil Procedure 4 and its state and same similarities. To ensure that the party has received constitutionally adequate notice of the proceedings instituted against them, affording a meaningful opportunity to be heard. Now, this is going to be an exemplar articulation for contesting personal jurisdiction and or a defective service. Okay, quote, objection, Your Honor. This tribunal is demonstrably lacking in personal jurisdiction over the respondent, who appears specially and not generally for the sole and limited purpose of contesting said jurisdiction. Respondent has manifestly insufficient minimum contact with this forum to satisfy the stringent constitutional requisites of due process. Furthermore, and in the alternative, service of process was fatally defective and failed to comply with the mandatory provisions of, and then of course you would cite the specific rule or statute with particularity, e.g. Rule 4 of the Federal Rules of Civil Procedure or the applicable state statute equivalent in that specify the precise nature of the defect with clarity. E.g., the service was not effectuated by a duly authorized individual. Service was improperly directed to an incorrect address. The summons itself was improperly formulated or lacked essential information, right? There are so many elements that must be proven within the information in which it is presented, right? And then that information conflicts with each other. Like my boy Quentin was just going through some things today, and what he's noticing and things right off the bat are definitely conflicting. And he had to ask the judge. The judge said, no, he ain't even read it. It's like, what? Come on, man. Like, you're supposed to be reading that. Like, you over here moving forward. You ain't even reading the elements of the case. Like, damn, on the record, boy. So absent legally sufficient service conferring personal jurisdiction in accordance with law, this court is without authority to proceed against this respondent, appearing sui juris and asserting all rights attendant thereto, unquote. So a challenge to personal jurisdiction frequently arises when a defendant is not domiciled within the state wherein the lawsuit or the claim is initiated. By way of illustration, if a domiciliary of Florida is sued in a California state tribunal concerning a contractual agreement that was negotiated and consummated entirely within the territorial confines of Florida, and the Florida domiciliary possesses no other significant or substantial affiliations with the state of California, they may possess a robust, I like that word, jurisprudential basis in contest, personal jurisdiction in California. The adjudicating court would then be compelled to meticulously analyze whether the defendant purposefully availed themselves of the privileges and immunities attendant upon conducting activities within California or has otherwise established systematic or continuous contacts with the forum state sufficient to warrant the exercise of such jurisdiction. Improper service of process constitutes a related yet distinct jurisprudential ground for objection. Even if a tribunal could potentially exercise personal jurisdiction over a defendant, it is precluded from doing so unless the defendant has been formally and properly notified of the lawsuit in strict or claim in strict accordance with the prevailing legal and constitutional mandates. Examples of such defective service which may deviate the proceedings include inter alia, service effectuated by an individual statutorily disqualified from performing such service, e.g., a party to the instant litigation, depositing the summons and complaint at a previous domicile where the defendant no longer maintains actual residence, omitting statutorily mandated documents from the service packet, e.g., failure to serve a copy of the complaint with the summons, employing a method of service not sanctioned by the applicable procedural rules under the specific circumstances, e.g., attempting service by publication where personal service is feasible and no order authorizing alternative service has been procured. Now, as all of my wise domians out there, when confronted with the institution of legal action, is duty bound to meticulously scrutinize both the asserted predicate for personal jurisdiction and the precise manner in which service of process was purportedly effectuated. A timely and jurisprudentially sound objection, with these grounds customarily interposed at the earliest practicable juncture, within a responsive pleading or a pre-answer motion to dismiss pursuant to 12b, is of crucial import. Neglecting to raise these objections with requisite propriety and promptitude can, by operation of law, result in a waiver of said defenses, thereby inadvertently submitting oneself to the tribunal's jurisdiction, even if such jurisdiction was initially deficient or altogether absent. It is furthermore often of crucial significance to apprehend that appearing in curia in contest the substantive merits of a case without first assiduously preserving an objection to personal jurisdiction may be construed by the court as a general appearance, which in and of itself can confer personal jurisdiction upon the tribunal. This objection underscores the fundamental jurisprudential principle that a court's power is not plenary but must be exercised strictly within the confines of constitutional due process and established legal rules. Now, what's crazy is you can go and even ask, Judge, can I get a continuing objection? Meaning that at every aspect, that continuing objection is in the relation of your appearance, especially and not generally. You dig what I'm saying? Get that continuing objection so you don't got to mention it every time, man. Or just mention it every time. I like to put it on the record every time. So the art of timing and strategic application of objections. The mere knowledge of legal objections, however comprehensive, remains an inert intellectual asset absent the cultivated skill of strategic deployment. The efficacy of an objection is inextricably linked to its timeliness, its articulation, and its alignment with the overarching objectives of the litigant. In this section is the nuanced considerations that govern the tactical application of objectives, transforming them from reactive interjections into proactive instruments of legal advocacy for all of my propria persona litigants out here in the world. The timing matrix, synchronizing objections with procedural junctures. The procedural timeline of any legal contest presents distinct phases, each offering unique opportunities and imposing specific constraints for the lodging of objections. A failure to appreciate these temporal parameters can render an otherwise valid objection mute or significantly diminish its impact. 1. Objections in limine. These are pretrial motions seeking a ruling from the court to exclude or admit certain evidence before the trial or hearing commences. The strategic advantage of a motion in limine is manifold. It allows for a consideration ruling outside the immediate pressure of trial, prevents the trier of fact from being exposed to potentially prejudicial information, even if it is ultimately excluded, and provides clarity for trial strategy. For example, a party might move in limine to exclude evidence of prior convictions if their prejudicial effect substantially outweighs their probative value. And this comes out of Federal Rules of Evidence 403-609. Similarly, one might seek to preclude an opponent from referencing inadmissible hearsay or unauthenticated documents. 2. Contemporaneous objections during trial and hearing. This is the most commonly visualized form of objection, raised immediately when improper evidence is offered, an inappropriate question is posed, or misconduct occurs. The cardinal rule is that the objection must be contemporaneous with the offending event. Delay, even momentarily, can be construed as a waiver. For instance, if a question calls for hearsay, the objection must be voiced before the witness answers. If an exhibit lacks foundation, the objection should be made when the exhibit is offered into evidence. See Federal Rules of Evidence 103A1, requiring a timely objection or motion to strike on the record, stating the specific ground if not apparent from the context. Point 3. Post-trial and post-hearing objections. Limited scope. While most objections must be contemporaneous, certain issues, particularly those relating to fundamental errors affecting substantive rights or substantial rights, or newly discovered evidence, may sometimes be raised post-trial, often through motions for a new trial or motions for judgment as a matter of law. However, reliance on post-trial objections is perilous and generally reserved for exceptional circumstances, where a contemporaneous objection was not feasible or where the error is so egregious as to constitute plain error. B. The preservation protocol, articulating objections for the record and appellate review. An objection serves a dual purpose: to seek an immediate ruling from the trial court and, crucially, to preserve the issue for potential appellate review should the ruling be adverse. Effective preservation requires adherence to a specific protocol. 1. Timely and specific articulation. As noted, the objection must be timely. Furthermore, it must state the specific legal grounds upon which it is based unless the ground is apparent from the context. A general objection such as, "Objection, Your Honor," is often insufficient, my nigga, to preserve the issue. For example, instead of merely saying, "Objection," one should state, "Objection, Your Honor. The question calls for hearsay," or "Objection, lack a foundation for this exhibit." 2. Securing a ruling. The litigant, this is a big one, y'all. The litigant must ensure that the court explicitly rules on the objection. If the court does not rule, or if the ruling is ambiguous, the litigant should respectfully request a clear ruling for the record. If you just say, okay, well, I don't agree, I don't understand, I comprehend, that ain't gonna work. Okay, that ain't gonna work. All right. You want to see if we can just get something real quickly that'll give us some examples. Let's ask. What are we gonna use? Chat. Give me some quick legalese quotes that revolve around the following that could be used. Let's see what we got. Paste, enter. Come on, I don't need you to think too hard now. It's very simple, okay? I'm using 03, but chill. Come on now. Give me some quick. Shouldn't take you that long. Look at me lagging, bro. No lag. Says it needs to pull direct quotes. You could just make up some quotes real quick. Jeez, wow. She really wants to take a while here. She's thinking hard here, Troy. Searching the web as well. Wow. Okay, now we're doing a full-on search. I just needed a quick response, but okay. Damn, now we're all the way over into the UK. Could have just pulled up this easy breezy little 1 minute reel I had on my Instagram, and that would have sufficed for all the waiting we're doing here, trying to get some easy made up quotes, but it seems wow. This is going in deep. I'm sorry for the wait. Excuse me. Dang. Super serious, huh? Jeez. Who would have known? It sure is given a lot, though. So actually, this is cool. I'm actually glad that she's about to produce this because, okay, cool. So here's some examples. She did a lot of searching, actually. Select authorities on necessity of securing an explicit ruling. Quote, simply filing the objection is not enough. You must obtain a ruling to preserve for appeal in writing, signed, and entered of record. Another quote, as a prerequisite to presenting a complaint for appellate review, the record must show that the trial court ruled on the request, objection, or motion, either expressly or implicitly, or refused to rule, and the complaining party objected to the refusal. To preserve error in the admission of evidence, a party must object and obtain an adverse ruling each time the complaint of evidence is presented, or secure a running objection. Quote, once the court rules definitively on the record, either before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. Another one, a formal exception to a ruling or order is unnecessary. When the ruling or order is requested or made, a party need only state that the action wanted on the grounds of the objection. And then another one, failure to obtain a ruling, often in the form of a written order, is an error preservation pitfall that can prove fatal on appeal. This one's big. This one goes to the heart of my girl, Sarah, right? Because they literally told her on the record that they are not going to give her a written determination. She has no way whatsoever to truly defend herself or get everything done correctly because of the fact that they're not giving her a written determination, and said that they don't care about nothing. They're not going to do it. We don't care. We don't give a damn what you talking about. We don't care. Essentially what they said. And that's kind of crazy. So it's cool. We got a couple of those real quick. Number 3, making an offer of proof if evidence excluded. Now, if the court sustains an objection and excludes evidence that the litigant believes is admissible and important, the litigant must make an offer of proof. This involves informing the court outside the hearing of the jury, if applicable, of the substance of the excluded evidence. This allows the appellate court to understand what the evidence would have shown and to assess whether its exclusion was erroneous and prejudicial. See Federal Rules of Civil Procedure 103A2. And then articulating constitutional grounds, if applicable. If an objection also implicates constitutional rights, of course, that confrontational clause of the due process, these constitutional grounds should be explicitly stated as part of the objection to ensure full preservation for higher review, particularly if seeking review by courts that prioritize constitutional issues. Thank you. By seeking review by courts that what? Prioritize constitutional issues. Because these lower courts don't do that. Clearly. They don't pay attention to the constitutional issues. Appellate alignment, framing objections with standards of review of mind. Now, when making objections, the astute litigant, of course, considers the standards by which an appellate court will review the trial court's rulings. Different types of errors are subject to different standards of review, which dictate the level of deference given to the trial court's decision. 1, the abuse of discretion. Now, many evidentiary rulings, such as those concerning relevance or prejudice under Federal Rules of Evidence 403, are reviewed for an abuse of discretion. This is in differential standard, meaning the appellate court will only reverse if the trial court's decision was clearly unreasonable, arbitrary, and unconscionable. A de novo review. Rulings on questions of law, such as the interpretation of a statute or a constitutional provision, are typically reviewed de novo. This means the appellate court gives no deference to the trial court's legal conclusions and examines the issue afresh. Plain error. If an objection was not properly preserved at trial, An appellate court will only review it for plain error. This is a very high bar, requiring a showing that 1, there was an error, 2, the error is plain or obvious, and 3, the error affected substantial rights, and 4, the error seriously affects the fairness, integrity, or public reputation of judicial proceedings. See Johnson versus United States 520 U.S. 461 1997, as well as Federal Rules of Criminal Procedure 52B. And structure error. These are constitutional defects affecting the framework within the trial proceeds, rather than simply an error in the trial process itself. Structural errors, such as the complete denial of counsel or biased judge, require automatic reversal without a showing of prejudice. Framing an objection to highlight a potential structural error, if applicable, is of utmost strategic importance. And understanding these standards, of course, will help you to frame better objections in a manner that maximizes the likelihood of a favorable ruling at trial, and if necessary, of course, a successful review on appeal. Now, the remedy ladder, escalating responses to sustained or overruled objections. Now, when an objection is made, the court will either sustain it, agree with the objection, or overrule it, disagree. The litigant's subsequent actions depend on this ruling and the nature of the issue. 1. If objection is sustained, evidence is questioned or excluded. The offending evidence is not admitted, or the improper question is not answered. The objecting party has achieved their immediate goal. 2. If objection is overruled, which is evidence allowed, question allowed. The evidence is admitted, or the witness answers the question. The objecting party must then consider further steps, requesting a limiting instruction. If prejudicial evidence is admitted for a limited purpose, the party may request the court to instruct the jury to consider the evidence only for that specific purpose and not for any other improper purpose. And that's coming from the Federal Rules of Evidence 105. Okay. And that's limiting evidence that is not admissible against other parties for other purposes. All right. Next, coming into a motion to strike. If an improper answer is given before an objection can be made, or if testimony is later revealed to be inadmissible, a motion to strike the offending testimony from the record is appropriate. If granted, the court will typically instruct the jury to disregard that testimony. Requesting a curative instruction. If improper information has reached the jury, a party may request a curative instruction where the judge tells the jury to disregard the information and explains why it was improper. This attempts to mitigate any prejudice. Considering a motion for mistrial or dismissal in extreme cases. If the introduction of improper evidence or misconduct is so prejudicial that a fair trial is no longer possible and curative instructions are deemed insufficient, a party may move for a mistrial in a jury trial or dismissal. This is a drastic remedy reserved for egregious errors that fundamentally undermine the integrity of the proceedings. Mastery of these strategic application guidelines will empower all of you to utilize objections not merely as defense tools, but as integral components of a proactive and principled legal strategy, ensuring that your voice is heard, your rights are protected, and that the pursuit of justice is conducted with procedural fidelity. Four, two, stop on the 6 and start on the 6 again. Yeah, I think that's where we're going to do that at. Getting in just a little bit of that good lingo. When you get to hear it, when you really get to hear it, you kind of get a little bit of the ins and outs of some of these things. It starts to make it really different. You dig what I'm saying? Like, you really get to start comprehending what's going on, right? In that comprehension, hearing it over and over and over. You haven't gone to law school. Some of you I haven't gone to law school, right? So every time that you refresh yourself with the information, your rights, how you can stand on them, how you can implement them, how you can tie this to that, how a lot of certain elements must be met on the forefront even to bring a claim against you. Like, it's so serious. And then the aspects of saying, okay, well, like Cam, like I mean, there's just so many elements on what they have to meet before they can just bring these charges against you. And I think once we start really realizing that and bringing that to the forefront is for invoking these doctrines, invoking these maxims, invoking everything that we need to invoke to be able to make sure that our rights are being protected. That's what we got to do. I mean, what else you want me to do other than continuously learn day in and day out? To get out here and constantly stand up on what we know is right, to challenge and buck the system, to stand with that metaphysical knowing of the responsibility that we have as not only material beings, but spiritual beings. Like, we have to benefit not only what we bring forth in this world, but what we manifest throughout all reality. And that goodness and that spirit of goodness in the world needs to be spread, but we have to give the education back to everybody. Like, it has to be brought forth. There's too much pain in this nation. We got to be the Band-Aid. We got to be the people that bridges the gap. We got to be the people that stops the harm for no reason whatsoever. And bring God and the gratitude of that back at the forefront. Hopefully y'all enjoyed some of these objections. Hopefully y'all enjoyed some of this objection talk. And we're going to get into some more on the next one. I guess we're going to start back up on 4.2, the procedural chronometry of objections and mastering timeliness. I'll see you on the next one, y'all. Peace and blessings. Remember, I am you, we are us, all a part of the great I am. I'll see you on the next one. Bye.